The sanctions decision has come down from Judge Linda V. Parker in the Kraken lawsuit sanctions decision. The decision is an amazing and entertaining and educational decision because it will explain what the sanctions are for, how we got here, and do so in a accessible way. A lot of these decisions, like the one about Prop 22, for example, they were a little bit complicated to get through. They were very dry and didn't really explain everything from start to finish. This reads like some kind of legal drama that you would write for TV. So let's just jump into it. Make yourself comfortable. If you're listening to this in podcast style, put me on in the background and just listen, because this is an amazing story that is going to be part of American history for the length of history. This lawsuit represents a historic and profound abuse of the judicial process. It is one thing to take the charge of vindicating rights associated with an allegedly fraudulent election. It is another to take on the charge of deceiving a federal court and the American people into believing that rights were infringed, without regard to whether any rights or laws were in fact violated. This is what happened here. Individuals may have a right within certain bounds to disseminate allegations of fraud unsupported by law or fact in the public sphere. But attorneys cannot exploit their privilege and access to the judicial process to do the same. And when an attorney has done so, sanctions are in order. Here's why. America's civil litigation system affords individuals the privilege to file a lawsuit and allege a violation of law. Individuals, however, must litigate within the established parameters for filing a claim. Such parameters are set forth in statutes, rules of civil procedure, local court rules, and professional rules of responsibility and ethics. Every attorney who files a claim on behalf of a client is charged with the obligation to know these statutes and rules, as well as the law allegedly violated. Specifically, attorneys have an obligation to the judiciary, their profession, and the public, 1, to conduct some degree of due diligence before presenting allegations as truth, 2, to advance only tenable claims, and 3, to proceed with a lawsuit in good faith and based on proper purpose. Attorneys also have an obligation to dismiss a lawsuit when it becomes clear that the requested relief is unavailable. This matter comes before the court upon allegations that plaintiffs' counsel did none of these things. To be clear, for the purpose of the pending sanctions motion, the court is neither being asked to decide, nor has it decided whether there was fraud in the 2020 presidential election in the state of Michigan. In fact, resolution of that issue was never appropriately before the court for the reasons stated in the court's December 7, 2020 ruling. Rather, the question before the court is whether plaintiffs' attorneys engaged in litigation practices that are abusive and, in turn, sanctionable. The short answer is yes. The attorneys who filed the instant lawsuit abused the well-established rules applicable to the litigation process by proffering claims not backed by law, proffering claims not backed by evidence, but instead speculation, conjecture, and suspicion, proffering factual allegations and claims without engaging in the required pre-filing inquiry, and dragging out these proceedings even after they acknowledged that it was too late to attain the relief sought. And this case was never about fraud. It was about undermining the people's faith in our democracy and debasing the judicial process to do so. While there are many arenas, including print, television, and social media, where protestations, conjecture, and speculation may be advanced, such expressions are neither permitted nor welcomed in a court of law. And while we as a country pride ourselves on the freedoms embodied within the First Amendment, it is well established that an attorney's freedom of speech is circumscribed upon entering the courtroom. Indeed, attorneys take an oath to uphold and honor our legal system. The sanctity of both the courtroom and the litigation process are preserved only when attorneys adhere to this oath and follow the rules, and only when courts impose sanctions when attorneys do not. And despite the haze of confusion, commotion, and chaos counsel intentionally attempted to create by filing this lawsuit, One thing is perfectly clear. Plaintiffs' attorneys have scorned their oath, flouted the rules, and attempted to undermine the integrity of the judiciary along the way. As such, the court is duty-bound to grant the motions for sanctions filed by defendants and is imposing sanctions pursuant to Rule 11, 28 U.S.C. 1927, and its own inherent authority. On November 3, 2020, a record 5.5 million Michigan residents voted in the presidential election, resulting in Biden securing over 150,000 more votes than Trump. By the following evening, President Biden had been declared the winner in the state. Even though Michigan law establishes an extensive procedure for challenging elections, plaintiffs did not avail themselves of those procedures as they conceded at the July 12, 2021 motion hearing before this court. That was the sanctions hearing. Instead, at 11:48 p.m. on November 25, 2020, the eve of the Thanksgiving holiday, plaintiffs filed the current lawsuit. The following lawyers electronically signed the pleading: Sidney Powell, Scott Hagerstrom, Gregory J. Rohl. The complaint listed the following attorneys as of counsel: Emily Newman, Julia Haller, L. Lin Wood, and Howard Kleinhendler. On November 29th, a Sunday, plaintiffs filed an emergency motion for declaratory, emergency, and permanent injunctive relief and memorandum in support thereof. The same attorneys who electronically signed or were listed as of counsel on the initial complaint signed or were listed on the amended pleading. The amended pleading also listed Brandyn Johnson as additional of counsel. In their amended complaint, plaintiffs alleged 3 claims pursuant to 42 U.S.C. 1983, which is a well-known civil rights statute. Violations of the Elections and Electors Clauses, the 14th Amendment Equal Protection Clause, and the 14th Amendment Due Process Clause. Under Count 4, plaintiffs asserted violations of the Michigan Election Code. Underlying plaintiffs' claims were their contentions that defendants, 1, failed to administer the November 3rd election in compliance with the manner prescribed by the law, and 2, committed a scheme and artifice to fraudulently and illegally manipulate the vote count to make certain the election of Joe Biden as President of the United States. Plaintiff asserted that their claims were supported by the affidavits of dozens of eyewitnesses and the statistical anomalies and mathematical impossibilities detailed in the affidavits of expert witnesses. Plaintiffs attached hundreds of pages as exhibits to their pleadings, some of which included affidavits from individuals and reports from purported experts. Most of these affidavits had been submitted by different lawyers in prior Michigan lawsuits challenging the 2020 presidential elections. These other lawsuits are Constantino and Benson. Plaintiffs asked the court to, among other things, decertify the election results and order defendants to transmit certified election results that state that President Donald Trump is the winner of the election. Plaintiffs maintain that this court had to issue this relief by December 8, 2020, because on that date, the results of the election would be considered conclusive. On December 7th, the court issued an opinion and order denying plaintiffs' motion and thereby declining to grant plaintiffs the relief that they wanted, which the court noted was stunning in its scope and breathtaking in its reach, as it sought to disenfranchise the votes of the more than 5.5 million Michigan citizens who participated in the general election. The court concluded that plaintiffs' lawsuit was subject to dismissal based on any one of several legal theories. 1, their claims were barred by 11th Amendment immunity. 2, their claims were barred under the doctrine of laches. Laches is when they say you've waited too long. It's an equitable doctrine, which means it's a fairness doctrine, not a statute or legal doctrine. So if you've got a law that you're relying on, that's one thing, and you've got a statute of limitations. But if you don't have that, you can argue fairness, equity, and laches is an equitable defense. 3, they lacked standing. 4, their claims were moot. And 5, abstention was appropriate under the doctrine set forth in Colorado River Water Conservation District v. United States, which I don't remember what that is, but you can look that up. But the court also concluded that plaintiffs were not likely to succeed on the merits of their claims. The court found plaintiffs' elections and electors' clauses claim was, in fact, a state law claim disguised as a federal claim. The court found the allegations to be based on nothing more than belief, conjecture, and speculation rather than fact. As to the due process claim, the court noted that plaintiffs abandoned it. The day after the court issued its decision, attorney Stephanie Lynn Gentilla entered her appearance in this matter and filed a notice of appeal to the Federal Circuit on behalf of plaintiffs. On December 11th, Sidney Powell, Stephanie Gentilla, and Howard Kleinhendler filed a petition for writ of certiorari, which is certification, to the United States Supreme Court. In that petition, when urging immediate Supreme Court review, plaintiffs wrote, once the electoral votes are cast on December 14, 2020, subsequent relief would be pointless. On December 15, 2020, the city served a letter called the Safe Harbor Letter and a motion, the Safe Harbor Motion, on plaintiffs' attorneys threatening sanctions pursuant to Rule 11 of the Federal Rules of Civil Procedure. The court will go into what that is in a moment. Specifically, counsel for the city sent the Safe Harbor Letter and motion via electronic mail and first-class mail to Sidney Powell, Gregory Rohl, Stephanie Gentilla, Scott Hagerstrom, Lin Wood, and Howard Kleinhendler. In the meantime, the Supreme Court did not rule on plaintiffs' petition for writ of certiorari by December 14th. The Supreme Court eventually denied the petition on February 22nd, 2021. On December 22nd, Davis filed a motion seeking sanctions against plaintiffs and their counsel. On the same day, motions to dismiss were filed by defendants. The city's motion to dismiss included 4 paragraphs discussing why plaintiffs and plaintiffs' counsel should be sanctioned. On January 14th, plaintiffs filed notices voluntarily dismissing the case as to the defendants. On January 26th, 2021, the parties stipulated to the dismissal of the matter on appeal. In the meantime, on January 5th, the city filed a Rule 11 motion for sanctions, for disciplinary action, and for disbarment referral, and for referral to state-barred disciplinary bodies. On January 28th, Governor Whitmer filed a motion for sanctions as well. On June 8th, the court scheduled a motions hearing for July 6th, and on June 17th ordered each attorney whose name appears on any of plaintiffs' pleadings or briefs to be present. Eventually, the hearing was scheduled for July 12th. Prior to the hearing, plaintiffs' attorneys retained counsel to represent them. The court conducted an almost 6-hour virtual hearing on July 12th. At the beginning of the hearing, the court explained that each question was directed to all attorneys. If no other attorney commented or added to the initial response to a question, the court would find that all the other attorneys agreed with the answer being placed on the record. At the end of the hearing, the court indicated that the attorneys could file supplemental briefs and supporting affidavits. Remember that affidavits are submitted under penalty of perjury. Supplemental briefs were subsequently filed. No attorney filed an affidavit. The defendants rely on 28 U.S.C. 1927, Federal Rule of Civil Procedure 11, and the court's inherent authority as the sources for sanctioning plaintiffs and/or their counsel. Defendants contend that sanctions are appropriate for 2 reasons. First, plaintiffs' counsel unreasonably and vexatiously multiplied the proceedings in this litigation by failing to dismiss the case when their claims became moot, which plainly occurred upon the vote of Michigan's electors on December 14th, if not earlier. Second, plaintiffs' counsel knew or should have known that their legal claims were frivolous, but counsel pursued them nonetheless, even after the court's opinion concluding that plaintiffs were unlikely to succeed on the merits of their claims for multiple reasons, which included the weakness of their legal claims and the lack of factual support. And sanctions pursuant to the court's inherent authority are appropriate because plaintiffs' claims were meritless, their counsel should have known this, and their real motive in filing suit was for an improper purpose. The state defendants also identify 3 specific allegations that they contend were not well grounded in fact. 1. The absentee voting counts in some counties in Michigan have likely been manipulated by a computer algorithm, and at some time after the 2016 election, software was installed that programmed tabulating machines to shift a percentage of absentee ballot votes from Trump to Biden. 2. Smartmatic and Dominion were founded by foreign oligarchs and dictators to ensure computerized ballot stuffing and vote manipulation to whatever level was needed to make certain Venezuelan dictator Hugo Chavez never lost another election. And 3. The several spikes cast solely for Biden could easily be produced in the Dominion system by preloading batches of blank ballots in files such as write-ins, then casting them all for Biden using the override procedure to cast write-in ballots that is available to the operator of the system. The city further contends that plaintiffs' allegations were not well grounded in fact in contravention of Rule 11. 1. Plaintiffs alleged that Republican challengers were not given meaningful access to the ballot processing and tabulation at the absent voter counting board located in Hall E of the TCF Center, knowing that the assertion lacked evidentiary support because it was rejected in Constantino, the state court case decided before plaintiffs filed the complaint. 2. Plaintiffs alleged that Republican challengers were exclusively barred from entering the TCF Center, knowing that the assertion was rejected in Constantino. Plaintiffs alleged that some absentee ballots were predated, knowing that that assertion was rejected in Constantino. Plaintiffs alleged that ballots were counted more than once, knowing that that assertion was both rejected in Constantino and conclusively disproven by the Wayne County canvass. 5. Plaintiffs alleged that a software weakness in Dominion machines upended Michigan's election results, knowing that the 2 instances of errors to which plaintiffs cite, one in Antrim County and one in Oakland County, did not constitute evidentiary support for the allegation. 6. Plaintiffs intentionally lied by filing the partially redacted declaration of Spyder, who plaintiffs identified as a former U.S. military intelligence expert and former electronic intelligence analyst with the 305th Military Intelligence, which was signed by Joshua Merritt, who never completed the entry-level training course at the 305th Military Intelligence Battalion and is not an intelligence analyst. 7. Plaintiffs intentionally lied by filing a declaration of Russell James Ramsland Jr., who claimed that there were reports of 6,000 votes in Antrim County that were switched from Trump to Biden and were only discoverable through a hand-counted manual recount when there were no hand recounts in Michigan as of that date. 2. Statistically improbable voter turnouts, including turnout of 782% in North Muskegon, where the publicly available official results were known as of election night to be approximately 70%, and a turnout of 461%, or elsewhere on the same chart, 91%, in Zeeland Charter Township, where it was already known to be 80%, and 3, that ballots can be run through again and again, effectively duplicating them when there were safeguards in place to prevent double counting of ballots in this way. And finally, 9, plaintiffs intentionally lied by filing the analysis of William M. Briggs, who relied on survey results posted in a tweet by Matt Brainerd, and the survey misrepresents Michigan election laws, disregards standard analytical procedures, contains a baffling array of inconsistent numbers, and includes conclusions that are without merit. Sanctions. Section 1927 of Title 28 provides that any attorney who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excessive costs, expenses, and attorney's fees reasonably incurred because of such conduct. The purpose of a sanctions award under this provision is to deter dilatory litigation practices and to punish aggressive tactics that far exceed zealous advocacy. Sanctions under Rule 11, B and C. B reads in part, by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney certifies to the best of their knowledge, information, and belief, formed after a inquiry reasonable under the circumstances, that 1. It is not being presented for an improper purpose, such as to harass, cause delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. And 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Much of the court's italicized language was added to Rule 11 in 1993. That will be important in a moment. Signatures. Plaintiffs' lawyers argue that no attorney can be sanctioned whose name appears only in typewritten form, that no attorney besides plaintiff's local counsel has appeared or signed a document filed in this matter, and that the court lacks jurisdiction to sanction any attorney who did not personally appear or sign a document filed in this matter. Yet, the local attorneys assert that although they signed the filings, they did not prepare them, and thus should not be responsible for them. As such, no attorney wants to take responsibility now that sanctions are sought for filing this lawsuit. In this age of electronic filing, it is frivolous to argue that an electronic signature on a pleading or motion is insufficient to subject the attorney to the court's jurisdiction if the attorney violates the jurisdiction's rules of professional conduct or a federal rule or statute establishing the standards of practice. And I would just like to add that this is seriously kids stuff. Like, if you've gotten through law school and you passed the bar exam and your professional responsibility examination, and you don't know that when you advocate something in court, when you sign it, when you file it, when you are of counsel, if you don't know that that subjects you to the court's jurisdiction, that's impossible. You're not a competent attorney if you're practicing before a court and you think that you're not within the court's jurisdiction for sanctions. That is just the stupidest thing I've ever heard. As set forth earlier, Sidney, Powell, Scott Hagerstrom, and Gregory Rohl electronically signed at least the complaint, amended complaint, and motion for injunctive relief. The remaining attorneys, except Gentilla, were listed as of counsel on one or more of the pleadings. The cases plaintiffs cite to support their argument that non-signing attorneys cannot be sanctioned were decided before the 1993 amendments to Rule 11. For the purposes of Rule 11, an attorney who is knowingly listed as counsel on a pleading, written motion, or other paper expressly authorized the signing, filing, submitting, or later advocating of the offending paper, and shares responsibility with the signer, filer, submitter, or advocate. At the July 12th hearing, Wood asserted for the first time that he was oblivious to his inclusion as counsel for plaintiffs in this case. The court will address this assertion separately. Notably, because Rule 11 only requires a signature by at least one attorney, documents are frequently presented to federal courts which list several attorneys as counsel but contain the signature of only one. Regardless, as amended in 1993, Rule 11 allows for sanctions on any attorney that violated the rules or is responsible for the violation. Moreover, Michigan Rule of Professional Conduct 8.5a reads, quote, "A lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. By agreeing to place their names on pleadings and/or motions, counsel are responsible for those submissions and will be held accountable." Now, my friends, it is once again time to change my hat. Only this time, I think my one tinfoil hat deserves a second tinfoil hat, because we're about to read the shenaniganery of Lin Wood. At the July 12th hearing, Wood maintained that the court lacks jurisdiction to sanction him because he played no role in drafting the complaint, did not read any of the documents with respect to the complaint, was not aware of the affidavits attached to it, and did not give permission for his name to be specifically included in this action. When the court asked Wood if he gave permission to have his name included on the pleadings or briefs, Wood answered, quote, "I do not specifically recall being asked about the Michigan complaint, but I had generally indicated to Sidney Powell that if she needed a quote-unquote trial lawyer, that I would certainly be willing and available to help her." And there's a footnote here. Wood, therefore, admittedly offered to provide legal services in this jurisdiction. Back to Wood's statement, "In this case, obviously my name was included. My experience or my skills apparently were never needed, so I didn't have any involvement with it. Would I have objected to be included by name? I don't believe so." The court then asked Wood if he gave Powell permission to include his name on the filings in this matter, to which he responded, quote, "I didn't object to it, but I did not know. I actually did not know at the time that my name was going to be included, but I certainly told Ms. Powell in discussions that I would help her if she needed me in any of these cases, and in this particular matter, apparently I was never needed, so I didn't have anything to do with it." Very, very brave of Lin Wood to take credit for all of that and then deny being involved in it later when it was sanctions time. Wood then denied being served with the motion for sanctions and stated that he was present only at the hearing because the court required him to be there. According to Wood, he only discovered that he had been included as counsel for plaintiffs in this matter when he saw a newspaper article about the sanctions motion. Quote, "I didn't receive any notice about this until I saw something in the newspaper about being sanctioned." When the court turned to Powell and asked whether she told Wood his name was being placed on the pleading, Powell first answered, quote, "My view, Your Honor, is that I did specifically ask Mr. Wood for his permission. I can't imagine that I would have put his name on any pleading without understanding that he had given me permission to do that." Powell then suggested that perhaps there was a misunderstanding between her and Wood. The existence of a misunderstanding seems improbable, given that several similar lawsuits seeking to overturn the presidential election results were filed in Georgia, Wisconsin, and Arizona, each bearing the same of counsel listing for Wood as appears here. And Kleinhendler did not recall whether he spoke to Wood before Wood's name was included on the pleading. The court does not believe that Wood was unaware of his inclusion as counsel in this case until a newspaper article alerted him to the sanctions motion filed against him, and this is why. First, the city's motion for sanctions was filed on January 5th, 2021. At no time between that date and the July 12th hearing did Wood ever notify the court that he had been impermissibly included as counsel for plaintiffs in this action. Almost a month before the motion hearing, the court entered an order requiring each attorney whose name appears on any of plaintiffs' pleadings or brief to be present at the hearing. Wood still did not submit anything to the court, claiming that his name was placed on those filings without his permission. No reasonable attorney would sit back silently if his or her name were listed as counsel in a case if permission to do so had not been given. Second, Wood is not credible. Notably, while Wood stated at the July 12th hearing that he only learned about the motion seeking sanctions against him when he read about it in a newspaper article, Wood suggests in his supplemental brief that he in fact learned of his purported involvement in the lawsuit when he received a call from one of the other attorneys in this matter in mid to late June 2021, alerting him of the court's order requiring him to appear at the hearing on the sanctions motion. So which is it? Was it a newspaper or a phone call? He claims that he was never served with the city's motion for sanctions. However, counsel for the city represents that the motion was sent to Wood via email and regular mail. Kimberly Hunt, the office manager for the city's attorneys, affirms in an affidavit that she mailed via first-class U.S. mail a copy of the safe harbor letter and motion to Wood, among others, on December 15th, 2020, and that no copies were returned as undeliverable. In the U.S., when you send mail to a party that doesn't live there anymore, it's possible somebody could throw it out, but it's also usually returned as undeliverable. You know, if you're trying to serve Wood at what I think is his P.O. box that's on his filings there, that's going to be his P.O. box, and if that's not his P.O. box anymore, then the postmaster is going to return the mail. And despite being told that he had an opportunity to attach an affidavit to his supplemental brief in order to put his oath behind his factual assertions, Wood surprisingly chose not to do so. Wood asserts in his supplemental brief that he and his legal assistant have performed a diligent search of all email correspondence as well as U.S. mail at Mr. Wood's Atlanta office and elsewhere. They have turned up no evidence to indicate that they were provided with any Rule 11 notice prior to the filing of the motion. Yet no affidavit is offered from Wood or his legal assistant to attest to these assertions. And notably, the address listed for Wood on the filings in this matter, and thus where the city's attorneys mailed items to him, is a post office box, not his firm's address. So he apparently searched his email and his law firm, but didn't check the post office box? I doubt it. More importantly, Wood's social media postings undermine his current assertions, as do his statements in other court proceedings. As discussed during the July 12th hearing, on the day the city emailed copies of the letter and motion to plaintiff's counsel, Wood tweeted a link to an article containing a copy of the motion, stating, "When you get falsely accused by the likes of David Fink and Mark Elias in a propaganda rag like Law and Crime, you smile, because you know you are over the target and the enemy is running scared." On January 5th, the day the city filed the motion, Wood tweeted a link to an article with the motion, stating that it was unfair for the city to seek sanctions against him. In a federal courtroom in the Eastern District of New York on January 11th, Wood acknowledged that the city was trying to get him disbarred. So Wood knew, according to his own statements reported by the court, as tweets and a federal court hearing, that he knew about the sanctions motion, yet he is apparently bald-faced lying to the court, trying to say that he didn't receive notice. And what would that get him anyway? If he didn't receive notice, then he could prove that to the court. All the court would do would provide him notice now and have him answer on some sort of briefing schedule. So I'm not even sure where that gets him, but instead, it's a bald-faced lie to the court, and I think it's Rule 3.3 of the lawyer's Rules of Professional Conduct, or at least the uniform ones, the ABA model rules. You have a duty of candor to any tribunal, which means duty of candor and honesty to the tribunal, which means you can't lie to the court or withhold material or germane information. So I think he's trying to get himself disbarred, is my opinion. Even more importantly, prior to the July 12th hearing, Wood took credit for filing this lawsuit. Notably, Rohl stated under oath that Wood, along with Powell, spearheaded this lawsuit, though the court hesitates to rely too much on the assertions of any of plaintiff's attorneys because their positions, as counsel for the city aptly describes, have been like shifting sands. The court notes that Rohl's sworn affidavit was attached to a supplemental brief filed by plaintiff's counsel in response to the city's motion for sanctions. No member of plaintiff's legal team has objected to any part of Rohl's affidavit. In a brief submitted to the Delaware Supreme Court, Wood also claims through his counsel, quote, "Wood represented plaintiffs challenging the results of the 2020 presidential election in Michigan and Wisconsin. In the days and weeks following the general election of 2020, Wood became involved in litigation contesting the election's results or the manner votes were taken or counted in critical swing states. Among those cases in which Wood became involved were lawsuits in Wisconsin, Michigan, and Wood's own suit in the state of Georgia." So he took credit and he took all of the, for lack of a better word, clout that comes with spearheading such a lawsuit. And then when it was time to pay the piper for your improper actions, he doesn't want anything to do with it. He'd never heard of anybody, doesn't know anybody, he doesn't know anything about it, wasn't given permission. It's absolutely undermines any credibility that he could have left. The court notes, "These statements are binding on Wood. For these reasons, while Wood now seeks to distance himself from this litigation to avoid sanctions, the court concludes that he was aware of this lawsuit when it was filed, was aware that he was identified as co-counsel for plaintiffs, and as a result shares the responsibility with the other lawyers for any sanctionable conduct." In lawyer land, violating the rules of professional conduct is usually grounds for disciplinary action. Violating your duty of honesty and candor to a tribunal, that's a disbarable or suspension-worthy offense. Even a single instance of it could get you some kind of suspension or even disbarment, depending on the size of the lie and your knowledge of the lie. Emily Newman and Gregory Rohl. Newman contends that she had a limited role in this lawsuit, having not played a role in drafting the complaint, spending maybe 5 hours on the matter from home. Therefore, Newman argues she should not be subject to sanctions. Newman does not suggest that her name was included without her permission. In addition, Newman does not cite case law suggesting that an attorney may not be sanctioned under the Rule 11 or any other source of sanctions authority if the time spent on the relevant lawsuit does not surpass an unidentified threshold. And Newman's responsibility for any Rule 11 violation is not diminished based on where those working hours were spent, particularly during a global pandemic when many individuals were working remotely from home. So long as the attorney bears some responsibility, the attorney may be sanctioned. In an affidavit filed in this case, Rohl stated that at approximately 6:30 p.m. on the day this lawsuit was filed, he was contacted by an associate who asked Rohl if he would assist in litigation involving alleged election fraud in Michigan. He thereafter received a copy of the already prepared 830-page initial complaint, and Rohl took well over an hour to review it. Making no additions, deletions, or corrections to the complaint, Rohl had his secretary file it at 11:48 p.m. To the extent Rohl asserts that he should not be sanctioned because he read the pleading only on the day of its filing, this argument does not fly. Rule 11b obviously requires that a pleading, written motion, or other paper be read before it is filed or submitted to the court. And the court finds it exceedingly difficult to believe that Rohl read an 830-page complaint in just well over an hour on the day he filed it. In other words, if it was well over 2 hours, he would have said well over 2 hours. So we can assume it's somewhere between 1 and 2 hours that he took to review the veracity of an 830-page complaint. It's sus. Let's just put it that way. So Rohl's argument in and of itself reveals sanctionable conduct. The court finds it even more difficult to believe that any inquiry Rohl may have conducted between the time he finished reading the complaint and 11:48 p.m. could be described as a reasonable one. But also, Rohl cannot hide behind his co-counsel. As a signer of the complaints, Rohl certified to the court that the claims asserted were not frivolous. Moreover, because his co-counsel were not admitted to practice in the Eastern District of Michigan, the complaints could not have been filed without Rohl's signature. Therefore, to the extent Rohl contends that he was only helping co-counsel, he still failed to fulfill his obligations as an officer of the court. Even if there are sanctions available under statutes or specific federal rules of procedure, the inherent authority of the court is an independent basis for sanctioning bad faith conduct in litigation. To award attorney's fees under this bad faith exception, a district court must find that 1. The claims advanced were meritless, 2. Counsel knew or should have known this, and 3. The motive for filing the suit was for an improper purpose such as harassment. And that's from the Big Yank case, which we're going to cite to a few more times. Plaintiffs' lawyers have been afforded due process here. Quick aside, due process is your right to the fair procedures of law and adjudication, your right to have notice of the claims against you, and a opportunity to respond that is meaningful before an unbiased tribunal or judge or jury. And so the plaintiffs are trying to say that they didn't get notice and a meaningful, fair opportunity to respond. Through the multiple motions for sanctions and related briefs, and during the July 12th motion hearing, they received notice of 1. Who the sanctions were being sought against, 2. The reasons why, 3. The authority pursuant to which sanctions were pursued, and 4. The types of sanctions requested. Counsel were provided the opportunity to answer the sanctions allegations in responsive briefs, orally at the 6-hour hearing, and in supplemental briefing. To the extent the court questioned plaintiffs' counsel about materials attached to their pleadings which had not been specifically addressed in movements briefs, counsel had an opportunity to respond to those concerns in supplemental briefs, and counsel did take advantage of that opportunity. The court first considers whether plaintiffs' counsel unreasonably and vexatiously multiplied proceedings by failing to dismiss this case, even when they acknowledged it became moot. Plaintiffs expressly acknowledged in their petition for writ of certiorari to the Supreme Court that once the electoral votes are cast, subsequent relief would be pointless and the petition would be moot. Michigan's electors cast their votes on December 14th, yet that date came and went with no acknowledgement by plaintiffs and their counsel to defendants or this court, forcing the state defendants to file motions to dismiss on December 22nd. During the July 12th motion hearing, Campbell contended that on December 14th, 3 plaintiffs were, in their opinion, properly elected as electors, as in the Electoral College. In other words, plaintiffs' attorneys maintain that this suit was no longer moot after December 14th because 3 plaintiffs subjectively believed that they had become electors. The attorneys cite no authority supporting the notion that an individual's personal opinion that he or she is an elector is sufficient to support the legal position that the individual is in fact an elector. Of course, such a belief is contrary to how electors are appointed in Michigan. Prior to the July 12th hearing, plaintiffs never told anyone about this newly formed subjective belief. They did not tell this court that the case would no longer be moot after December 8th, despite telling this court the exact opposite when filing this lawsuit on December 25th. And they did not tell the Supreme Court that the case would no longer be moot after December 14th, despite telling that court the exact opposite on December 11th. The fact that it was never shared suggests that counsel's argument as to why the case had to be pursued after December 14th is contrived. If events that occur subsequent to the filing of a lawsuit deprive the court of the ability to give meaningful relief, then the case is moot and must be dismissed. Here, plaintiffs conceded that their claims were moot after December 14th, yet, in the month that followed, plaintiffs refused to voluntarily dismiss their claims, forcing defendants to file their motions to dismiss and the court to decide plaintiffs' motion for additional time to respond to the motions to dismiss, which plaintiffs ultimately did not do. In the end, plaintiffs' attorneys prolonged the inevitable and caused both the state defendants and the intervenor defendants and the court to waste resources in the meantime. Plaintiffs' attorneys also take issue with the state defendants' use of the Big Yank case, pointing out that the court stated, according to plaintiffs' counsel, that the bad faith exception requires that the district court make actual findings of fact that demonstrate that the claims were pursued for an improper purpose. You'll also hear the findings of fact be referred to as an evidentiary hearing. But the portion of the Big Yank opinion cited discusses a court's inherent authority to sanction, not sanctions under 1927 as pursued by the state defendants. The court finds that plaintiffs' counsel unreasonably and vexatiously multiplied the proceedings in this case, and their arguments to the contrary are unavailing. Whether plaintiffs violated Rule 11. The court said it before and will say it again. At the inception of this lawsuit, all of the plaintiffs' claims were barred by the doctrines of mootness, laches, and standing, and the 11th Amendment immunity. Further, plaintiffs' attorneys did not provide a non-frivolous argument for extending, modifying, reversing existing law, or for establishing new law to render their claims ripe or timely, to grant them standing, or to avoid 11th Amendment immunity. The same can be said for plaintiffs' claims under the elections and electors clauses, the Equal Protection Clause, the Due Process Clause, and the alleged violations of the Michigan Election Code. Finally, the attorneys have not identified any authority that would enable a federal court to grant the relief sought in this lawsuit. Remember, Michigan is a state. The state has control over how it enacts the election, how it carries out the election. So why would you sue in federal court for a state issue? As the court said previously, it's a wolf in sheep's clothing. Plaintiffs asked this court to enjoin the state defendants from sending Michigan certified results to the Electoral College, but as reported publicly, Governor Whitmer had already done so before the plaintiffs filed this lawsuit. Plaintiffs sought the impoundment of all voting machines in Michigan. However, those machines are owned and maintained by Michigan's local governments, which are not parties to this lawsuit. Plaintiffs demanded the recount of absentee ballots, but granting such relief would have been contrary to Michigan law, as the deadline for requesting and completing a recount had already passed by the time plaintiffs filed suit. Further, a recount may only be requested by a candidate, And while plaintiffs requested the above relief, their ultimate goal was the decertification of Michigan's presidential election results and the certification of the losing candidate as the winner. Relief which is not warranted by existing law or a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. While courts do have the authority to grant injunctive relief affecting conduct related to elections, no case suggests that courts possess the authority to issue an injunction of the scope or breadth sought here. Plaintiffs' attorneys maintain that the strongest case is Bush v. Gore, the Supreme Court case from the 2000 election. There, however, the Supreme Court was asked neither to order a recount nor to decertify Florida's presidential election results. Instead, the court was asked to stop a recount ordered by the Florida Supreme Court, which infringed the state's legislatively enacted scheme. Ultimately, the court halted the Florida recount of the presidential election to allow the previously certified vote results to stand. At the July 12th hearing in this case, plaintiffs' counsel pointed for the first time to the Supreme Court's decision in U.S. v. Throckmorton, a 1878 Supreme Court case, as supporting this court's authority to take, it seems the attorneys are suggesting, any equitable action in connection with the 2020 presidential election. Remember, equity is a fairness doctrine. We're not arguing that a law says it, we're arguing that it's unfair. And so it's kind of a fallback position for a 2020 presidential election when we actually have laws on these things. Apparently, Throckmorton's quotation of the maxim, "fraud vitiates everything," is a refrain that has been oft repeated on social media by those who question the results of the 2020 presidential election and believe former President Trump should be declared the winner. Of course, the Supreme Court did not hold in Throckmorton that fraud vitiates everything. Rather, it merely quoted this phrase from a treatise and then held that, in fact, fraud does not justify overturning a federal district court's 20-year-old decree. The city is correct that plaintiffs' counsel's citation to Throckmorton is puzzling, both because the case relates to a 19th century land grant and has nothing to do with election law, and because the Supreme Court held that the grant could not be collaterally attacked on the basis that the judgment was procured by fraud. And I have a note here, a collateral attack is an attack on a prior judgment in a new case, also known as an indirect attack. Counsel's citation to Throckmorton is enlightening in that it reflects, as the city puts it, that this suit has been driven by partisan political posturing, entirely disconnected from the law, and is the dangerous product of an online feedback loop, with the attorneys citing legal precedent derived not from a serious analysis of case law, but from the rantings of conspiracy theorists sharing amateur analysis and legal fantasy in their social media echo chambers. It is not lost upon the court that the same claims and requested relief that plaintiffs' attorneys presented here were disposed of for many of the same reasons in Michigan courts and by judges in several other battleground jurisdictions where plaintiffs' counsel sought to overturn the election results. The fact that no federal district court considering the issues at bar has found them worthy of moving forward supports the conclusion that plaintiffs' claims are frivolous. To support the allegation that defendants violated Michigan election laws by accepting unsecured ballots without any chain of custody, the amended complaint states that Whitney Myers observed passengers in cars dropping off more ballots than there were people in the car. But when the court asked plaintiffs' counsel whether individuals other than the voter can drop off a ballot in Michigan, Campbell answered in the affirmative. And of course, anyone could easily have learned this by consulting Michigan law. See Michigan Compendium of Laws 168-764A. A household member or family member as defined by Michigan law may return a voter's absentee ballot. It seems to the court then that plaintiffs' counsel knew or should have known that this conduct did not violate existing state law. The amended complaint further claims that Michigan election laws were violated because ballots lacked postmarks, yet were counted. When one searches through the unindexed affidavits attached as Exhibit 3 to plaintiff's pleading and eventually locates these affidavits, however, one finds that none of the affiants state that ballots without postmarks were counted. But when the court asked plaintiffs' attorneys whether Michigan absentee ballots must be received through U.S. mail and therefore postmarked to be counted, counsel went on about not being able to rely on the Secretary of State's guidance. Noticeably absent from that response, however, was an answer to the court's question. Tellingly, when the city's council stated that ballots are not required to be mailed or postmarked in Michigan, as they are often handed in by hand via boxes in front of the clerk's offices by hand, and sometimes right across the desk in the clerk's office by hand. Plaintiffs' counsel did not object or refute this recitation of the law. See Michigan Compendium of Laws 168-764A. Absentee ballots may be delivered personally to the office of the clerk, to the clerk, or to an authorized assistant of the clerk, or to a secure drop box. To support the allegation that defendants counted ineligible ballots, and in many cases multiple times in violation of Michigan election law, the amended complaint cites to several affidavits in which the affiants state that batches of ballots were repeatedly run through the vote tabulation machines. When the court asked whether plaintiffs' counsel inquired as to why a stack of ballots might be run through tabulation machines more than once, plaintiffs' counsel did not answer the court's question, and instead proclaimed that ballots are not supposed to be put through more than once. Absolutely not. That would violate Michigan law. But bafflingly, plaintiffs' counsel did not offer a cite to the law violated, and counsel did not identify such a law in the amended complaint either. However, the affidavit of Christopher Thomas, senior advisor to the Detroit City Clerk, filed in the Constantino case, known as the Thomas Affidavit, he explained that ballots are often fed through the high-speed reader more than once as a routine part of the tabulation process, and he detailed myriad reasons why this may be necessary, including if there is a jam in the reader or if there is a problem ballot, with stains or tears or stray markings, etc., in a stack. Thomas goes on to explain, to an untrained observer, it may appear that the ballot is being counted twice. However, the election worker will have canceled the appropriate count on the computer screen. Any human error in the process would be identified during the canvass. If not, the number of voters at the absent voter counting board would be dramatically different than the number of counted votes. At the July 12th hearing, Kleinhendler told the court that it was completely irrelevant whether the conduct plaintiffs claimed was violative of Michigan law was actually unlawful. This is because, counsel argued, the conduct raised a suspicion, and what was significant was the mere chance for misfeasance to occur. To make his point, Kleinhendler used the analogy of handing someone an open can of Coke and assuring the recipient that a drink had not been taken from it. But it is just as plausible that the can had been sipped before delivery as it is plausible that it had not been. A pleading must contain something more than a statement of facts that merely creates a suspicion of legally cognizable right of action, and the court cites to Bell Atlantic v. Twombly. This is very, very basic jurisdictional law that you learn in law school and is tested on the bar exam. This is kids' stuff. But litigants and attorneys cannot come to federal court asserting that certain acts violate the law based only upon an opportunity for, or counsel and the litigant's suspicions of a violation. In light of plaintiff's allegation that defendants violated the Michigan Election Code by permitting ballots to arrive at the TCF Center not in sealed ballot boxes, without any chain of custody, and without envelopes, and because the amended complaint does not identify a provision in the Michigan Election Code prohibiting the actions about which plaintiffs complain, the court asked plaintiffs' attorneys at the July 12th hearing about their understanding regarding Michigan's ballot bin requirements. Counsel's response: "We do not purport to be experts in Michigan's process." What? We do not purport to be experts in Michigan's process. That's Rule 1-1. That's your lawyer's duty of competency. A lawyer cannot represent people, cannot act as a lawyer in a representative capacity if they are not competent. And yes, it is a self-identified process. where you have to decide how many cases you can take before you're not competent to take anymore, or which topics of law or subjects of law you take cases in, because maybe you're not competent in family law, but you're good at bankruptcy law. That's your self-determination, but it is subject to disciplinary review later on. To admit we are not experts in Michigan's process meant you're not competent to represent in a case about Michigan's process. And they argued the affidavit that supported this allegation, the Gustafson affidavit from Daniel Gustafson, was copied and pasted from Constantino. These evasive and non-responsive answers to the court's direct questions amount to an admission that plaintiff's counsel did not bother to find out what the Michigan Election Code requires and whether the acts alleged to constitute violations of the Election Code were actually prohibited. In Constantino, which was decided approximately 2 weeks before plaintiffs filed the instant lawsuit, Wayne County Circuit Court Judge Timothy M. Kenny credited the Thomas affidavit, thereby informing plaintiffs' counsel that what Gustafson observed did not in fact violate Michigan Election Code, or at a minimum, putting counsel on notice that there was a duty to inquire further. And even if plaintiffs' counsel lacked expertise as to the Michigan Election Code, they undoubtedly were required to be familiar enough with its provisions to confirm that the conduct they asserted violated the code, in fact, did. The court finds plaintiffs' counsel's arguments to the contrary unavailing. First, the attorneys assert that neither opposing counsel nor the Thomas affidavit took issue with the facts as outlined in the Gustafson affidavit, and therefore the Gustafson affidavit does not suggest that plaintiffs' counsel engaged in any conduct worthy of sanctions. This misses the point. The sanctionable conduct is not based on whether the facts described in the Gustafson affidavit are true or false. What is sanctionable is counsel's allegation that violations of the Michigan Code occurred based on those facts, without bothering to figure out if Michigan law actually prohibited those acts as described. Second, plaintiffs' counsel argued that permitting ballots to be handled and transported in the manner described in the Gustafson affidavit raises a suspicion, and whether such acts are required under Michigan law or not is completely irrelevant. But the amended complaint repeatedly asserts that defendants violated the Michigan Election Code and plaintiff's state law, equal protection, due process, the electors and elections clauses. These claims are based on these alleged violations. And again, a mere suspicion is not enough. This is especially so when neither the litigant nor his or her counsel has bothered to figure out exactly what the law is or what it permits. For these reasons, the court concludes that plaintiffs' attorneys presented claims not warranted by existing law or a non-frivolous argument for extending, modifying, or reversing existing law. Sanctions under 11b-3. Plaintiffs' attorneys argue that they genuinely believed the factual allegations in this lawsuit and otherwise filed this lawsuit and the accompanying documents in good faith. They also argue that the affiants genuinely believed the same and submitted their affidavits also in good faith. Because all of this was done in good faith, counsel contends, they should not be sanctioned. Of course, an empty head but pure heart does not justify lodging patently unsupported factual assertions. That's an amazing sentence. An empty head but pure heart does not justify lodging patently unsupported factual assertions. Patently asserting something means you've asserted it on its face. It doesn't need to be dug into. It's right there on the shiny outside leather of a patent leather shoe. So that's an amazing sentence. She just called the lawyer's conduct empty-headed. And the good or bad faith nature of actions or submissions is not what determines whether sanctions are warranted under Rule 11b-3. What the city claims and the court agrees is sanctionable as a violation of the rule is the filing of pleadings claiming violations of the Michigan Elections Code, etc., where the factual contentions asserted to support those claims lack evidentiary support. The court spent significant time during the July 12th hearing inquiring about the various reports and affidavits plaintiffs attached to their pleadings, not necessarily because plaintiffs' counsel may have filed the lawsuit in bad faith, and not necessarily because the affiants may have submitted their affidavits in bad faith, Rather, the court did so because no reasonable attorney would accept the assertions in those reports and affidavits as fact or as support for factual allegations in a pleading when based on such speculation and conjecture, and no reasonable attorney would repeat them as fact or as support for a factual allegation without conducting the due diligence inquiry required under Rule 11b. And here's where you might want to take a moment to refresh yourself, go to the bathroom, get some food, get ready, because here is where it's about to get really good. Plaintiffs' counsel failed to present any evidence to support their allegation of illegal double voting. To support this factual assertion, plaintiffs pointed to a single piece of evidence, the affidavit of Jesse Jacob. That affidavit states in part, "I observed a large number of people who came to the satellite location to vote in person, but they had already applied for an absentee ballot." Michigan law makes it a felony to vote both in person and absentee, in other words, to do both. Of course, Jacob does not state that these individuals voted in person and also voted absentee. As such, her affidavit, in fact, does not plausibly support illegal double voting. Of course, applying for an absentee ballot is not evidence that someone voted via an absentee ballot, and when the court highlighted this lack of evidence as to double voting during the hearing, plaintiffs' counsel responded, "I think there's inferences that can be drawn, and it should not shock this court that somebody could show up after having asked for an absentee ballot and then show up and vote again." It does not shock the court that a Michigan resident can request an absentee ballot and thereafter decide to vote in person. Indeed, Michigan law says that voters can. An absent voter may vote in person within his or her precinct at an election, notwithstanding that he or she applies for an absent voter ballot and the ballot is mailed or otherwise delivered to the absent voter by the clerk. If, before voting in person, the absent voter returns the absent voter ballot. But the court is concerned that plaintiffs' attorneys believe that a Michigan resident's choice to do so serves as circumstantial evidence that the Michigan resident double voted. It does not. Inferences must be reasonable and come from facts, proven, not speculation or conjecture. Plaintiffs' counsel presented affidavits that were based on conjecture, speculation, and guesswork. To support the allegation that unsecured ballots arrived at the TCF Center loading garage, not in sealed ballot boxes, without any chain of custody, and without envelopes after the 8 p.m. Election Day deadline, plaintiffs quote the affidavit of Matt Ciantar, I'm going to call him Ciantar, which is a masterclass on making conjectural leaps and bounds. The afternoon following the election, as I was taking my normal dog walk, I witnessed a dark van pull into a small post office located in downtown Plymouth, Michigan. I witnessed a young couple pull into the parking lot and proceed to exit their van, no markings, and open up the back latch and proceed to take 3 to 4 very large clear plastic bags out and walk them over to a running USPS delivery vehicle that appeared as if it was waiting for them. There was no interaction between the couple and any USPS employee, which I felt was very odd. They did not walk inside the post office like a normal customer to drop off mail. It was as if the postal worker was told to meet and stand by until these large bags arrived. The bags were clear plastic with markings in black on the bag, and on the inside of these clear bags was another plastic bag that was not clear, could not see what was inside. There were what looked like a black security zip tie on each back, as if it were tamper-evident type of device to secure the bag. By the time I realized I should take pictures of the bags, once I noticed this looked odd, they had taken off. Ooh, scary. Something happened that I don't know what it is. The other oddity was that the appearance of the couple. After the drop, they were smiling, laughing at one another. Ooh, this couple dropped off mail and afterward they were smiling and laughing. What I witnessed and considered that what could be in those bags could be ballots going to the TCF Center or coming from the TCF Center. When the court asked plaintiffs' attorneys how any of them, as officers of the court, could present this affidavit as factual support of anything alleged in their pleadings and motion, counsel emphatically argued that the witness is setting forth exactly what he observed, and the information that he bases it on. He saw these plastic bags. It is a true affidavit. The court accepts that the affidavit is true in that Seantor memorialized what he saw at the time, but the court cannot find it reasonable to assert, as plaintiffs' attorneys do, that this shows fraud. Absolutely nothing about this affidavit supports the allegation that ballots were delivered to the TCF Center after the Election Day deadline, and even if the court entertained the assertion of plaintiffs' counsel that this affidavit is one piece of a pattern reflecting fraud or defendants' violations of Michigan election laws, this would be a picture with many holes. This is because a document containing the lengthy musings of one dog walker after encountering a smiling, laughing couple delivering bags of unidentified items in no way serves as evidence that state laws were violated or that fraud occurred. During the hearing, plaintiffs' counsel further asserted that we don't typically rewrite what an affiant says. That is good. But pursuant to their duties as officers of the court, attorneys typically do not offer factual allegations that have no hope of passing as evidentiary support at any stage of the litigation. To support the allegation that defendants fraudulently added tens of thousands of new ballots to the qualified voter file on November 4th, 2020, all or nearly all of which were votes for Joe Biden, plaintiff quotes the affidavit of Marissa Carone, which describes facts that demonstrate no misconduct or malfeasance and amount to no more than strained and disjointed innuendo of something similar. There was 2 vans that pulled into the garage, she says, of the counting room, one on day shift and one on night shift. These vans were apparently bringing food into the building. I never saw any food coming out of these vans. Coincidentally, it was announced on the news that Michigan had discovered over 100,000 more ballots, not even 2 hours after the last van left. The amended complaint calls this an illegal vote dump. But nothing described by Carone connects the vans to any ballots, nothing connects the illusory ballots to President Biden, and nothing connects the illusory votes for President Biden to the 100,000 ballots coincidentally announced on the news as discovered in Michigan. Yet, not a single member of plaintiff's legal team spoke with Carone to fill in these speculation-filled gaps before using her affidavit to support the allegation that tens of thousands of votes for President Biden were fraudulently added. Without engaging in such an inquiry, much less a reasonable one, counsel's affirmative decision to label the 100,000 ballots discussed on the news, or the illusory ballots theoretically removed from 2 vans, as an illegal vote dump, serves as a quintessential example of guesswork laced with bad faith. It is also notable that when the court asked plaintiff's counsel whether an affiant's observation of a self-described coincidence serves as evidentiary support for the allegation that an illegal vote dump occurred, plaintiff's counsel appeared to say that it was okay in this case, because Ramsland relied on the Carone affidavit for his statistical analysis, and an expert can rely on hearsay. But the problem with the Carone affidavit does not concern hearsay, it concerns conjecture. And surely plaintiff's attorneys cannot fail to reasonably inquire into an affiant's speculative statements and thereafter escape their duty to stop and think before making factual allegations based on the statement simply because their expert did the same. Plaintiff's counsel further emphasized that if Carone said things that don't turn out to be entirely accurate, that can be discovered through the processes that this court is very familiar with. The court assumes the attorneys are referring to the discovery process, but here's the snag. Plaintiffs are not entitled to rely on the discovery process to mine for evidence that never existed in the first place. A plaintiff may not rely on discovery to manufacture a claim that lacks factual support in the first instance, but a plaintiff may use discovery to bolster evidence. And speculation, coincidence, and innuendo could never amount to evidence of an illegal vote dump, much less anything else. The Supreme Court has made clear, quoting Twombly again, very, very basic jurisdictional law. The Supreme Court has made clear that where there are perfectly plausible alternative explanations for an event, here, for example, legally cast ballots simply being delivered and counted, a plaintiff's allegations are not to be accepted as true. From Twombly, explaining the need at the pleading stage for allegations plausibly suggesting, not merely consistent with, liability. And of course, the mere fact that the affiant and or plaintiff's counsel opted to use seemingly sinister language to describe an event does not make that event sinister, wrongful, unlawful, or fraudulent. To support the allegation that defendants permitted election workers to change votes for Trump and other Republican candidates, plaintiffs point to one thing, namely Artisha Boehmer's affidavit. She says, "I observed a station where election workers were working on scanned ballots that had issues that needed to be manually corrected. I believe some of these workers were changing the votes that had been cast for Donald Trump and other Republican candidates." Per the amended complaint, this is the only evidence and only eyewitness testimony of election workers manually changing votes for Trump to votes for Biden. When the court asked whether an affiant's belief that something occurred constitutes evidentiary support for that occurrence, plaintiff's counsel stated, "If you see it, that would certainly help you form a belief." The court then asked, "Did anyone inquire as to whether or not Boehmer actually saw someone change a vote?" The court was met with silence. As an initial matter, an affiant's subjective belief that an event occurred does not constitute evidence that the event in fact occurred. But more importantly, during the hearing, plaintiff's counsel conceded that the Boehmer affidavit had evidentiary value only if Boehmer saw election workers manually changing votes for former President Trump to votes for Biden. Yet, without asking Boehmer if she saw such manual changes, plaintiff's counsel submitted her affidavit as evidentiary support that such manual changes in fact occurred. This alone fell short of counsel's obligation to conduct a reasonable inquiry and is the very laxity that the sanctions schemes are designed to penalize. And plaintiff's counsel's failure to ask this material question, when paired with their affirmative decision to label Boehmer's testimony as eyewitness testimony of election workers manually changing votes, it evinces bad faith. Plaintiff's counsel may not bury their heads in the sand and thereafter make affirmative proclamations about what occurred above ground. In such cases, this willful ignorance is not bliss, it is sanctionable. As evidentiary support in this case, plaintiff's counsel attached affidavits to their pleadings that were submitted into previously filed election challenge lawsuits without engaging in a reasonable inquiry as to their contents. To support the allegation that defendants fraudulently added tens of thousands of new ballots and or new voters to the qualified voter file, plaintiffs quoted the Cito affidavit. When the court inquired about factual assertions in the Cito affidavit, Kleinhendler responded that these were affidavits that were submitted by counsel in Constantino. Plaintiffs' attorneys admit to similarly lifting the Carone affidavit from Constantino and filing it in this case as evidentiary support without engaging in an independent inquiry as to its merits. The attorneys admit the same as to the Boehmer affidavit and suggest the same as to the Jacob affidavit. In fact, almost every, if not every, non-expert affidavit attached to plaintiff's pleadings here was filed by other attorneys in prior lawsuits. When the court asked whether plaintiff's counsel inquired as to the affidavits copied and pasted from the other cases, plaintiff's counsel dipped and dodged the question and did not disclaim the city's counsel's assertions that they did not. Quote, "Other lawyers saw it and they believed for it to be appropriate for submission to the court in that circumstance." Quote, "You've got to be able to trust when something has been submitted by counsel because of the oath that we take, knowing that everybody else within the profession therefore believes that the attorney's submission should have tremendous value." I'm not part of the everybody else, just FYI, I did not believe. Clearly, plaintiff's counsel relied on the assessment of counsel for the plaintiffs in other cases as to the affidavits from those cases that plaintiff's counsel recycled here. This is not okay. The court remains baffled after trying to ascertain what convinced plaintiff's counsel otherwise. Substituting another lawyer's judgment for one's own does not constitute a reasonable inquiry. In short, plaintiff's counsel cannot hide behind the attorneys who filed Constantino or any other case to establish that plaintiff's counsel fulfilled their duty to ensure that the affidavits they pointed to as evidentiary support for the pleadings here in fact had any chance of ever amounting to evidence. In their supplemental brief in support of their motion for sanctions, the state contends that plaintiff's counsel failed to engage in the requisite pre-filing inquiry, pointing to several statements Powell made in an election-related defamation case. We've covered a bit of this case in the Dominion Sanctions lawsuit, which is based in part on allegations made in the instant lawsuit. In a motion to dismiss filed in that case, Sidney Powell argued that, even if the plaintiffs attempt to impugn the various declarations as unreliable or attack the veracity or reliability of the various declarants, lawyers involved in fast-moving litigation concerning matters of transcendent public importance who rely on sworn declarations are entitled to no less protection than journalists who usually repeat statements from sources, usually unsworn, often anonymous, on whom they rely for their stories, and sometimes those statements turn out not to be true. Journalists, like attorneys, Powell argued, must be free to rely on sources they deem to be credible without being second-guessed by irate public figures who believe that the journalists should have been more skeptical. Attorneys are not journalists. It therefore comes as no surprise that plaintiffs' attorneys fail to cite a single case suggesting that the two professions share comparable duties and responsibilities. Perhaps this confused understanding as to the job of an attorney and what the law says about the attendant duties and obligations is what led plaintiffs' counsel to simply copy and paste affidavits from prior lawsuits. Perhaps not. But what is certain is that plaintiffs' counsel will not escape accountability for their failure to conduct due diligence before recycling affidavits from other cases to support their pleadings here. Plaintiffs' counsel attached Ramsland's affidavit to their pleadings to support the assertion that hundreds of thousands of illegal votes were injected into Michigan's election for president. In his affidavit, Ramsland refers to several statistical red flags, including 1. The reports of 6,000 votes in Antrim County being switched from Trump to Biden, and 2. 643 precincts in Michigan with voter turnout exceeding 80%. 460% in Zeeland Township, 215% in Grout Township, Gladwin County, 139% in Detroit. However, the state issued a bulletin well before this lawsuit was filed, explaining the user error that led to the miscount in Antrim County's unofficial results, which had been quickly identified and corrected. And official election results for Michigan, reporting voter turnout rates vastly lower than the numbers in Ramsland's affidavit, were published and readily available shortly after the election and well before his report filed here. Ramsland fails to identify the source of his figures in the initial affidavit presented in this case, indicating only that he and his colleagues have studied the information that is publicly available concerning the election results. He astoundingly claims, however, that some larger precincts in Wayne County and others are no longer publicly reporting their data. And after it was widely reported that Ramsland's figures were grossly inaccurate, plaintiffs' counsel submitted new numbers from Ramsland in an expert report filed December 3rd, where Ramsland claims that the source of the original data was state-level data that no longer exists for some unexplained reason, and for the first time identifies those purported sources. A reasonable attorney seeing Ramsland's striking original figures would inquire into their accuracy or at least question their source. Even the most basic internet inquiry would have alerted plaintiffs' counsel to the wildly inaccurate assertions in Ramsland's affidavit. For example, in comparison to the voter turnout of 139% in the city of Detroit claimed by Ramsland, the official turnout was recorded on or before November 19th as being 50.88%. Ramsland reported voter turnout in Zeeland Charter Township was 460.51%, when an official report ran on November 11th showed that the average turnout for the 4 precincts within the township was 80%. And unlike Ramsland's assertion of an eye-popping 782% turnout in the city of North Muskegon, the 2 precincts in the city had a turnout of 74 and 82%, averaging 78%, as indicated as of November 13th. And before plaintiff's counsel presented Ramsland's affidavit here, there was more to alert them as to the unreliability of Ramsland's figures and to put them on notice that further inquiry was warranted. Specifically, attorneys used an affidavit from Ramsland in Wood's challenge to the presidential election results in Georgia, but there, Ramsland represented data as being from Michigan when, in fact, the townships listed were in Minnesota. Moreover, it was widely publicized before plaintiff's counsel offered Ramsland's affidavit here that even for the Minnesota locations, Ramsland's conclusions about overvotes was not supported by official data from the state. It is true, as plaintiff's attorneys assert to defend their use of Ramsland's affidavit, that Ramsland adjusted his voter turnout figures in a subsequently filed report. However, counsel never drew attention to this modification in the reply brief to which Ramsland's updated report was attached or anywhere else. But, more importantly, this does not change the fact that a reasonable inquiry was not done before Ramsland's initial affidavit was presented. For the reasons above, the court concludes that plaintiff's counsel presented pleadings for which the factual contentions lacked evidentiary support. Then the court goes on to improper purpose. The court already concluded that plaintiff's counsel acted with an improper purpose when affirmatively labeling as an illegal vote dump the 100,000 ballots discussed on the news, despite failing to inquire as to the gaps that established the relevant affidavit as nothing more than conjecture. Evidence of improper purpose can also be found in their decision to label as eyewitness testimony an affidavit that does not state that the affiant saw election workers manually changing votes, especially when opting not to ask the affiant if she saw such a thing. And still, evidence of bad faith abounds. First, Campbell filed an emergency motion within hours of the July 12th hearing's conclusion, asking the court to publicly release the recording of the proceeding. In that motion, some of the attorneys representing plaintiffs argued on June 17th, the court issued an order that each of the attorneys whose names appear must be present. Media around the country picked it up. Indicative of the public's interest, the sanctions hearing at its peak attracted more than 13,000 people watching the live video on YouTube, as broadcasted by the court. The national media ran stories on the hearing. Most outlets presented a narrative that counsel for plaintiffs believed to be incorrect. Those characterizations may change if the court republishes the video and allows others to view it. Counsel is unable to refute what they believe to be public mischaracterizations. There was a lot of spirit in the hearing in this court, which the public should be able to experience in its entirety, enabling the citizens to draw their own inferences from the presentations instead of depending on media presentations. Notwithstanding the apparent belief of plaintiff's counsel, this case is being tried in a court of law, not the court of public opinion. As noted throughout this decision, statutes, rules, and standards of professional responsibility apply. Considering plaintiff's attorney's obligation to act within these parameters, this court is curious as to what narrative plaintiff's attorneys wish to present through the video's release. The Telegram message Wood posted within hours of the hearing's conclusion gives some insight. In the post, Wood expressed, in part, that he thought he was attending a hearing in Venezuela or communist China. He further expressed that the rule of law and due process does not exist at this time and in our country, except in a very, very few courtrooms. Also telling are the introductory remarks in plaintiff's counsel's supplemental brief. What is most important, however, and what very clearly reflects bad faith, is that plaintiff's attorneys are trying to use the judicial process to frame a public narrative. Absent evidentiary or legal support for their claims, this seems to be one of the primary purposes of this lawsuit. Second, there is a basis to conclude that plaintiff's legal team asserted the allegations in their pleadings as opinion rather than fact, with the purpose of furthering counsel's political positions rather than pursuing any attainable legal relief. Several of the allegations asserted in this and similar lawsuits filed by plaintiff's attorneys are now the subject of a lawsuit that the companies responsible for the Dominion election machines filed against Powell and her company defending the Republic. In response to the Dominion plaintiff's claim that Powell's assertions here were defamatory, Powell has maintained that the statements were opinions which reasonable people would not accept as fact. This deserves 2 tinfoil hats. If I can even figure out how to put a tinfoil hat on a tinfoil hat. So she says, these statements were opinions which reasonable people would not accept as fact. Powell makes clear that at least some of the allegations in the current lawsuit were made to support her chosen political candidate. Specifically, Powell's brief in support of her motion to dismiss in the Dominion action states, given the highly charged and political context of the statements, it is clear that Powell's statements were made as an attorney advocate for her preferred candidate and in support of her legal and political positions. The highly charged and political nature of the statements, Powell continues in her brief, underscores their political and hence partisan nature. Powell characterizes her statements and allegations as vituperative, abusive, and inexact, political speech, as well as inherently prone to exaggeration and hyperbole. Powell latched on to the Dominion plaintiff's assertion that her allegations amounted to wild accusations and outlandish claims, and therefore, she argued, reasonable people would not accept these alleged statements and allegations as fact, but view them only as claims that await testing by courts through the adversary process. So she was real big on claiming this Kraken lawsuit and what it was going to do, and she was okay with accepting all of the fame and fortune that came her way. But now that it's time to pay the piper, she has no responsibility. Those were not facts. Those were just opinions in favor of her preferred candidate. It is not acceptable to support a lawsuit with opinions, which counsel herself claims no reasonable person would accept as fact, and which were inexact, exaggerated, and hyperbole. And think about it this way. Would you want to be sued? Nobody wants to be sued, but would you want to be sued because of somebody's opinion? No, you'd hope that if you were sued, it made sense. Something happened, you had a car accident, we're turning over our apartment and we have a dispute with the landlord. You're not going to do it because of someone's opinion. You hope. You wouldn't want to be sued that way. If you could avoid being sued at all, great. But if you had to be sued, you'd want it to be a proper founded lawsuit, not something based entirely on someone's opinion and their soreness that they lost the election, that their candidate lost the election, that something in life happened differently than they wanted it to, so therefore they're going to sue you. No. Nor is it acceptable to use the federal judiciary as a political forum to satisfy one's political agenda. Such behavior by an attorney in a court of law has consequences. Although the First Amendment may allow plaintiffs' counsel to say what they desire on social media, in press conferences, or on television, federal courts are reserved for hearing genuine legal disputes which are well-grounded in fact and law. The court pauses to briefly discuss plaintiff's attorney's attempt to cloak their conduct in this litigation under First Amendment protection. The attorneys have argued, quote, setting a precedent to sanction an attorney whose case is denied at the district court level on procedural grounds is a grave abuse of the disciplinary process and potentially constitutes intimidation for filing a grievance against the government, which is a core protection of the First Amendment. The attorneys have further argued that a sanctions order would implicate plaintiffs and their counsel's First Amendment right of access to the courts. These attorneys are incorrect. An attorney's right to free speech while litigating an action is extremely circumscribed. As the Sixth Circuit explained in the Mezebov case, it is not surprising that courts have thus far been reluctant to allow the First Amendment to intrude into the courtroom. At first blush, the courtroom seems like the quintessential arena for public debate, but upon closer analysis, it is clear this is not and has never been an arena for free debate. An attorney's speech in court and in motion papers has always been tightly cabined by various procedural and evidentiary rules, along with the heavy hand of judicial discretion. And in the courtroom, the First Amendment rights of everyone, attorneys included, are at their constitutional nadir. Attorneys voluntarily agree to relinquish their rights to free expression in judicial proceedings and voluntarily accept almost unconditional restraints on their personal speech rights when before a court. For that reason, the Sixth Circuit has seen no basis for concluding that free speech rights are violated by a restriction on that expression. Third, the court finds an improper purpose because plaintiffs' counsel failed to conduct the pre-filing reasonable inquiry required of them as officers of the court, despite most of the attorneys acknowledging that no one is immune to confirmation bias, and therefore attorneys should look beyond their prejudices and political beliefs to view evidence with a level of professional skepticism. Plaintiffs' attorneys attempt to excuse their failure to objectively evaluate their evidence because they are not the only individuals who reviewed the affidavits attached to their pleadings as evidence of serious fraud. They say former President Trump suspected it too, and millions of Americans believe that their president would not intentionally mislead them. As officers of the court, plaintiffs' counsel had an obligation to do more than repeat opinions and beliefs, even if shared by millions. Something does not become plausible simply because it is repeated many, many times by people. This is a lesson that some of the darkest periods of history have taught us. Counsel's failure to look beyond their prejudices and political beliefs during this litigation and before filing this lawsuit strongly suggest improper motive. The evidence of bad faith and improper motive becomes undeniably clear when paired with the fact that plaintiffs' counsel violated Rule 11 in a multitude of ways. In other words, by failing to take the basic pre-filing steps that any reasonable attorney would have taken, and by flouting well-established pleading standards, all while knowing the risk associated with failing to remain professionally skeptical, plaintiffs' counsel did everything in their power to ensure that their bias that the election was fraudulent as proclaimed by former President Trump, that their bias was confirmed. Confirmation bias notwithstanding, plaintiffs' counsel advanced this lawsuit for an improper purpose and will be held to account for their actions. Fourth, circumstances suggest that this lawsuit was not about vindicating rights in the wake of alleged election fraud. Instead, it was about ensuring that a preferred political candidate remained in the presidential seat despite the decision of the nation's voters to unseat him. Before the 2020 general election, Powell appears to have been certain that those who did not support President Trump already engaged in fraudulent illegal activity. On Election Day, Powell gave an interview during which he described the many multifaceted efforts the Democrats are making to steal the vote, including developing a computer system to alter votes electronically, spreading the COVID apocalypse hoax, and ensuring that people have not gotten their absentee ballots, even though they've requested them 3 different times and been told they were canceled. The court says, why would someone who believes that election fraud is already happening and will likely reach peak levels on Election Day not raise the alarm with the entity the individual claims can fix things, specifically the judiciary? It is because plaintiffs' counsel was equally certain, even before the polls closed, that President Trump was going to win. And then the court cites to her statement claiming that the results of the 2020 election would be the Trump victory, and stating that Democrats have effectively conceded that Trump is going to win at the voting booth. Indeed, says the court, plaintiffs' attorneys waited until after the votes were tallied to file this lawsuit, even though the record suggests that well in advance of Election Day, they knew or should have known about the things of which they complained. And that's a great place to describe the laches defense. The laches argument to dismiss the plaintiff's claim. Why would they have waited? They should have presented what they knew when they knew it, or shortly thereafter, rather than waiting to see who won and then present all of these, challenges to absentee voting and all that. The absentee voting system was established well before November 3rd. No one was surprised that there was absentee voting. So why didn't they challenge that ahead of time and similar things? So they waited so long therefore Latches applies. This game of wait and see shows that counsel planned to challenge the legitimacy of the election if and only if former President Trump lost. And if that happened, they would help foster a predetermined narrative making election fraud the culprit. These things, separately, but especially collectively, evince bad faith and improper purpose in bringing this suit. Fifth, Joshua Merritt is someone whose identity counsel redacted, referring to him only as Spyder, and who counsel identified in their pleadings and briefs as a former electronic intelligence analyst with the 305th Military Intelligence and a U.S. military intelligence expert. Yet, even after learning that Merritt never completed any intelligence analyst training program with the 305th Military Intelligence Battalion, plaintiffs' counsel remains silent as to this fact. In its motion for sanctions, the city emphasizes Merritt's statement that the original paperwork he sent in to plaintiffs' counsel didn't say that he was an electronic intelligence analyst under the 305th Military Intelligence. According to the city, a spokesman for the U.S. Army Intelligence Center for Excellence, which includes that battalion, stated that Merritt kept washing out of courses. He's not an intelligence analyst. Plaintiffs' counsel did not dispute these assertions in their response brief, nor did plaintiffs' counsel dispute these assertions during the July 12th hearing. Instead, Kleinhendler argued during the hearing that Merritt's expertise is based on his years and years of experience in cybersecurity as a confidential informant for the U.S. government, not Merritt's purported military intelligence training. Clearly, this is dishonest. This was not the experience on which plaintiffs' attorneys premised Merritt's expertise in their pleadings and motion, and Merritt never claims in his declaration that he has years and years of experience in cybersecurity as a confidential informant for the U.S. government. Instead, it was precisely Merritt's experience as an electronic intelligence analyst under the 305th Military Intelligence that plaintiffs' attorneys presented to convince the court and the world that he is a reliable expert. Kleinhendler argued during the hearing, however, that he first learned about this inconsistency after the case was dismissed on January 14th. I had no reason to doubt, Kleinhendler explained. This is also dishonest. First, the city attached an article from the Washington Post to its January 5 motion for sanctions, which at least put plaintiffs' counsel on notice that Merritt lacked the expertise they claimed. Yet curiously, during the hearing, when the court asked if anyone asked plaintiffs' counsel if or suggested to them that Merritt was not a military intelligence expert, Kleinhendler, Haller, and Powell said no, and all other counsel agreed by remaining silent. Second, the court finds it implausible, for several conspicuous reasons, that absolutely no member of plaintiffs' legal team learned of the Washington Post article and the questions it raised shortly after it was published on December 11th, 2020. This is especially so considering that, according to the Washington Post article, when asked about Merritt's limited experience in military intelligence, Powell stated in a text to the Washington Post, "I cannot confirm that Joshua Merritt is even Spyder. Strongly encourage you not to print." Kleinhendler further argued that plaintiffs' counsel's assertion that Merritt was a U.S. military intelligence expert was not technically false or technically wrong because he did spend, from Kleinhendler's understanding, 7 months in training with the 305th. The court is unconvinced by this effort to mischaracterize. Kleinhendler himself admitted that labeling Merritt as a U.S. military intelligence expert is not the full story. Surely, any reasonable attorney would find it prudent to be forthcoming after learning that one of his experts never actually completed the training upon which the expert's purported expertise is based. And Kleinhendler appears to concede that this argument is a poor one because he nonetheless admits that had he known in advance of the January 14th dismissal that Merritt had transferred out, he would have made it clear. But this is yet another misrepresentation. As detailed above, by January 5th, Kleinhendler knew Merritt never completed the training that formed the basis of his purported expertise. Yet Kleinhendler did not make it clear. Co-counsel for plaintiffs also had reason to question Merritt's expertise by no later than January 5th, yet they remained silent too. Ultimately, plaintiffs' counsel's decision to not make clear the full story about Merritt not completing military intelligence training was for the improper purpose of bolstering their star witness's expertise and misleading the court, opposing counsel, and the world into believing that Merritt was something he was not. Finally, despite what this court said in its December 7th decision and what several other state and federal courts have ruled in similar election challenge lawsuits, plaintiffs' lawyers brazenly assert that they would file the same complaints again. They make this assertion even after witnessing the events of January 6th and the dangers posed by narratives like the one counsel crafted here. An attorney who willingly continues to assert claims doomed to fail and which have incited violence before must be deemed to be acting with an improper motive. In sum, each of the 6 matters discussed above individually evince bad faith and improper purpose, but when viewed collectively, they reveal an even more powerful truth. Once it appeared that their preferred political candidate's grasp on the presidency was slipping away, plaintiffs' counsel helped mold the predetermined narrative about election fraud by lodging this federal lawsuit based on evidence that they actively refused to investigate or question with the requisite level of professional skepticism, and this refusal was to ensure that the evidence conformed with the predetermined narrative, a narrative that has had dangerous and violent consequences. Plaintiffs' counsel politically motivated accusations, allegations, and gamesmanship may be protected by the First Amendment when posted on Twitter or shared on Telegram or repeated on television. The nation's courts, however, are reserved for hearing legitimate causes of action. In summary, the court concludes that plaintiffs' counsel filed this lawsuit in bad faith and for an improper purpose. They presented pleadings that were not warranted, as we just said, and they failed to voluntarily dismiss the lawsuit on the date that plaintiffs' counsel acknowledged it would be moot, which I think was December 14th. For these reasons, the court holds that sanctions are warranted according to Rule 11, Section 1927, and the court's inherent authority. Sanctions are required to deter the filing of future frivolous lawsuits designed primarily to spread the narrative that our election processes are rigged and our democratic institutions cannot be trusted. Notably, many people have latched onto this narrative, citing as proof counsel's submissions in this case. The narrative may have originated or been repeated by former President Trump, and it may be one that many Americans share. However, that neither renders it true nor justifies counsel's exploitation of the courts to further spread it. Sanctions imposed. This lawsuit should never have been filed. Defendants should never have had to defend it. If plaintiffs' attorneys are not ordered to reimburse the state defendants and the city for the reasonable fees and costs incurred to defend this action, counsel will not be deterred from continuing to abuse the judicial system to publicize their narrative. Moreover, this court has found that plaintiffs' counsel initiated this litigation for an improper purpose, rendering this the unusual circumstance in which awarding attorneys' fees is warranted. Further, given the deficiencies in the pleadings, which claim violations of Michigan election law without a thorough understanding of what the law requires, and the number of failed election challenge lawsuits that plaintiffs' attorneys have filed, the court concludes that the sanctions imposed should include mandatory continuing legal education in the subjects of pleading standards and election law. Lastly, the conduct of plaintiffs' counsel, which also constituted violations of the Michigan Rules of Professional Conduct, MRPC 3.1 and 3.3, I guessed right, calls into question their fitness to practice law. This warrants a referral for investigation and possible suspension or disbarment to the appropriate disciplinary authority for every state bar and federal court in which each attorney is admitted. Accordingly, it is ordered that the motions for sanctions filed by the state and the city are granted. The court is granting in part and denying in part Davis motions for sanctions, in that the court finds sanctions warranted but not an award of Davis reasonable attorney's fees or costs. It is further ordered that plaintiffs' attorneys shall jointly and severally pay the fees and costs incurred by the state defendants and the city of Detroit to defend this action. Jointly and severally is a big deal. It means every one of them is liable for the entire amount. It's not like $2,000 to this one attorney and $100,000 to a different attorney. It's $102,000 and you're all liable for it. We don't know what the amount is yet. The city now has 14 days to submit its time and expense records, and plaintiffs may object within 14 days, and the court will issue a final ruling, which I will cover. It is further ordered that plaintiffs' attorneys shall each complete 12 hours of continuing legal education in the subjects of pleading standards, at least 6 hours, and election law, at least 6 hours. Within 6 months of this decision, any courses must be offered by a nonpartisan organization and must be paid for at counsel's expense. Within 6 months of this decision, each attorney representing plaintiffs shall file an affidavit in this case describing the content and length of the courses attended to satisfy this requirement. It is further ordered that the clerk of the court shall send a copy of this decision to the Michigan Attorney Grievance Commission and the appropriate disciplinary authority for the jurisdictions where each attorney is admitted, referring the matter for investigation and possible suspension or disbarment. Sidney Powell of Texas, Lin Wood, Georgia, Emily Newman, Virginia, Julia Haller, District of Columbia, Maryland, New York, and New Jersey. Well, that's impressive. Brandyn Johnson, D.C., New York, and Nevada. Scott Hagerstrom, Michigan. Howard Kleinhendler, New York, and New Jersey. Gregory Rohl, Michigan. And Stephanie Gentilla, Michigan. It is so ordered. Linda V. Parker, U.S. District Judge, August 25th, 2021. Holy mackerel. And that should give you some good understanding of the heightened standards that attorneys are held to. You can't just go into court and shout opinions and accuse people of things without any kind of evidence or basis to do so. Now, I fully expect that this decision will be appealed. It might need to be made final before it can be appealed, which means the judge might have to hear the responses, issue a judgment as to what the sanctions amount is, and then maybe the plaintiffs can challenge the sanctions motion. They would have to do so on some very interesting standards. The standard of review for questions of law is de novo, which means the court can review questions of law brand new, but there's very little law in this. Everything is either a determination of fact or is within the court's discretion, which means it either needs to be clearly erroneous, that the judge relied on some fact that is clearly erroneous, or it has to be an abuse of the court's discretion, and that's a really high standard to meet. So I'm really not sure that the appeals court or the Supreme Court is going to take up this sanctions decision and deny the court's decision really in any way. Maybe the most likely thing is that the appeals court or Supreme Court might limit the attorney's fees award, but we'll have to see that as it happens. Either way, I will cover that for you. Thank you for joining me. I hope you were entertained, but more importantly, I hope you now were educated as to why attorneys aren't allowed to do what these attorneys were doing. And I really hope that these attorneys have learned their lesson. And, you know, I have to admit some personal bias against Sidney Powell and Lin Wood. I don't think they should be practicing law at all for how easy it was for them to overlook their oaths, their duties, their rules of professional conduct, and the Rule 11, 1927, and inherent powers for sanctions to do what they did. It was obviously more important to them to do what they did. Think of it this way. Is there an amount of money where you would break the law or leave your job or abandon your family or something? It crossed the line for these people. There's something, some motive, whether it be financial or personal gain or something, motivated these people to violate all of these duties because they gained something. So that's incredibly suspicious, so suspicious that these people lack credibility. Let me know what you think in the comments below. Thanks for getting through that one. Love you all. Bye. And that's today's video. Special thanks to our top supporters in August: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, Brandyn Abel, ShadowTycho, RDHDragon, Earthbound Star, Pure Magma, Drew Hart, and Eric Tams. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye. Like the court previously said, it's a wool in sheep's clothing. It's a wolf. Sheep have wool, so I see how my brain got there, but